one article is called Voluntary Liquidity, and that's if you want to sell your interest. And generally, as simple as it is, the company, the manager, and the other members would like the first right of refusal to buy that interest from you, because we want to keep all the interest in the company. That isn't really what we're talking about today. We're talking about the other article that talks about involuntary liquidity. And the one thing we're talking about is death. What happens when the investor dies? Are those the type of clauses that you see in documents that you review, Rick?
Yes, I do. And that was the important first point of discussion. Just what is the investor committed to in the actual syndication documents? And like you, we find that when someone passes away, that it is not covered in the syndication documents. It's left to state law and what the investor has done in taking title.
That's right. The operating agreement, there's no place in the operating agreement to say, depending upon how you take title, this is what's going to happen when you die. You know, it's moot on that. But when you say it's community property, and that's how you take title, that sets a lot of things in motion. So I think we're going to talk about 5 or 6 of the common ways that people take title. And then I think you want to talk about some other things. You want to mention a little bit about step-up basis and whatever it is we can provide our clients and the listeners some good information. I think I'm happy to do that. So Rick and I have come up with a list that we want to talk about. We're going to talk about, okay, how did they take title? Now they're dead. What happens to that interest? First one we talked about, or we want to talk about, is what happens if an unmarried investor, or at least an investor who's taking title as a single man. Okay?
That's right.
Okay. Now, what do you do? So they take title that way, and Gene Trowbridge takes title. He's an unmarried guy. He's a single man, and he dies. What happens, Rick?
So in that case, we look for several things. The general rule is that when you pass away owning title in your own name, generally a probate occurs. Now, probate, the purpose of probate is to determine who gets legal title to the actual investment. Now, here in California, we have a benchmark. If the value of the investment is less than about $165,000, then you don't go through the formal probate of about a year. You go through a small probate that is done by a small estate affidavit. Now, typically, every state has this small estate affidavit based on their threshold, and it allows an investor who has less than, let's say, the statutory amount, not to have to go through a probate, but to submit a one-document small estate affidavit to the syndicator, who will then go ahead and make the transfer according to the terms of the small estate affidavit. So the first thing we look for is, what's the value of the investment? And once the value of the investment is determined, you either go through a formal probate or you do not. And that's the first key. Then, if you have to go through a probate, typically you may have a will. And the will merely directs where the investment goes, that is, who will receive the actual investment. It doesn't avoid probate. If you have no will, then in our state, California, in fact, every state has made a will for you. We call that intestate succession. So if an unmarried investor passes away with no will, then the state, like California, will say where it goes. And oftentimes it doesn't go where the investor wanted it to go. So your best option is to at least have a will where you direct where the asset will go. In terms of the basis, now basis is a tax concept. And if the investor put in $50,000 and now it's worth $200,000, then in the hands of the beneficiary or the people who inherit it, the new income tax basis will be $200,000. So if they choose to sell it, the first $200,000 should be free of any income tax. Anything above the $200,000 will be taxed. So we have 2 points for every one of our discussions. We need to know what the value of the asset was. And we also need to understand, is there a will or is there no will? Because that determines if you have a formal probate or if you have a small estate affidavit.
So that's very interesting. So let's say we go through that and someone new ends up with the ownership. Now in my document, they have the ownership, so they can come in the voluntary liquidity provision and sell that, because they may not want that share, they may want the money.
That's correct.
So their step up, I think in my document it's Article 11, they step up to Article 11 as an owner, and then they can go through the process to liquidate. Okay, that's more complicated than I thought because of the probate issue. Now you said, even if they have a will, it's going to go through, depending upon the state that they're in, some level of probate.
That is correct. That is correct. Remember, when we don't know who is to receive title, that's what the probate court is doing. Probate is strictly trying to determine who gets legal title to the asset. And they have a series of procedures, creditors, and all that to make sure that all the bills are paid, the debts are paid, and that the right person who is to receive it actually receives it.
So Rick, in the case of a single person and there's a death, I don't want my syndicator to have to deal with the probate. How do we get that into probate? Do we have to find a next of kin, or we have to hire an attorney and say, hey, Gene died, you need to deal with this? Is that how we get that in there without my syndicator having to do it?
Yes, in fact, that's a very good point. If the asset has to go through a formal probate, nothing happens until you petition the court to have someone appointed as the executor or the administrator who can then take control of the asset and move it through the probate process. So typically, if you have a will, you will name the executor,
right,
who will be the one in charge. If there's no will, then it goes to a pecking order in terms of the blood relationship. So the closest in blood to the unmarried investor, it could be parents, it could be a brother or sister, it could be a niece or nephew. They would have standing to bring the petition in probate, then get control of the asset, move it through the probate process, and then depending upon the will, or if there's no will, what the state dictates, the property will then be distributed to the right party. And that's why the judge is there to do it.
Interesting. Let's talk about, we have an awful lot of investors in California and in Texas and the other community property states. If a couple took title in community property, and let's say one of the spouses die, in community property, that spouse has the right to do with their assets as they choose, right? So what happens there?
So basically, community property is just a 50-50 proposition. So if the investor and their spouse, if the investor takes title as community property, then one half is owned by the spouse and one half is owned by the investor. And that's the legal title. Now, the spouse owns one half So therefore, that half is off the table. But the other half will now be determined by what the deceased investor did. If the deceased investor had a will and left everything to his or her spouse, then we call it a spousal property petition that the surviving spouse uses to have the judge order the deceased investor's interest to pass to the surviving spouse. And that should be consistent in all 9 of the community property states. Okay. If the will says that the deceased investor's interest goes to his parent or to a brother, that's a different issue, because community property doesn't mean that the surviving spouse gets the deceased investor's interest automatically. So you look to the will to see what is said. If there's no will, then the surviving spouse will go to court to get a spousal property petition. And here in California, when a person dies and they own a property as community property, then the surviving spouse is entitled to receive that community property. It requires a 1-court hearing spousal property petition that will be filed. Other documents are provided, and then the surviving spouse should be able to get the other interest. So it depends, Gene, on what people do in their estate planning documents to determine if a surviving spouse receives the asset or if they do not. In terms of the basis, community property has a distinct advantage. What that means is that when the deceased investor passes away, both his or her interest and the spouse's interest get a basis adjustment to the fair market value. So what that means is that if they invested $100,000 and now it's worth $200,000, well, the spouse contributed half of that as well as the deceased investor. So the general rule is when a person dies, their interest gets a basis adjustment to the fair market value. Community property says, well, not only does the deceased investor get a basis adjustment, but the surviving spouse gets a stepped up basis at the same time. So the surviving spouse can take this new asset, this asset worth now $200,000, come to the syndicator and say, I'd like to sell, collect the $200,000, no income tax due. So that's a big advantage to community property.
It is. What about an investor who takes title as, 2 investors take title as joint tenants with the right of survival?
Joint tenancy with right of survivorship avoids probate, no matter what the amount. It stands for joint tenancy with right of survivorship. So when the investor passes away, the investor's interest automatically goes to the other surviving joint tenants.
Without even a will.
Without even a will.
That's
no
right.
Will. And frankly, Gene, if they had a will, the joint tenancy trumps the will. It goes to the surviving joint tenant.
Mm-hmm.
And
when my grandmother died, her house had been put in title between her and my mother as joint tenants with right of survival. So when grandma died, my mother ended up with 100% ownership of that house, just like that.
That's right. And all your mother had to do was just file a deed called an affidavit death of joint tenant, and that transferred title automatically. So there was no need to go to the judge to determine who got legal title. It was already set forth.
Interesting.
Now for the basis interest, Gene, a little bit different. Unlike community property, joint tenancy, the interest of the deceased joint tenant, their interest only gets a basis adjustment to the fair market value. So in the case that they both put in $50,000, $100,000 total, and it's now worth $200,000, the deceased investor's interest will now be worth from $50,000 to $100,000, but the surviving joint tenant still has a basis of $50,000. So if they sold the asset for 200,000, the surviving joint tenant is going to have a capital gain typically of $50,000 to pay.
Okay, that makes sense. We have a lot of people who invest in their family trust. Okay, and typically it's a husband and wife, they have a family trust like I do. And one of us dies. What happens then?
In that case, it's rather simple. Trust, avoid probate. And the reason they avoid probate is that when someone passes away, there's no question as to who owns legal title. The trust owned legal title before death. The trust still owned legal title after death. So there's no necessity to go through probate. Then the terms of the trust would determine who receives the interest. And that should be outlined in every trust as to the event of death, who receives it. Now, the basis step up is a different issue. In a trust, you can own community property and you can own separate property. If the asset is the community property of the deceased investor and spouse, then as mentioned before, both sides get a basis step up to the fair market value, so the surviving spouse can sell the asset and have no income tax to pay. If it's separate property, then that interest will itself get a stepped up basis to the fair market value. So in the case of husband and wife, it generally doesn't make any difference. But for purposes of what we have here, I think the family trust is by far the superior way to hold title to an asset like this.
So in my situation, community property and a family trust. So I would imagine, I haven't looked at my documents, but I would imagine in a situation like that, I die. My will probably tells me that my interest goes into the family trust.
That's right.
And stays with, and now Kay, who's the sole remaining trustee, is in charge of everything. And it hasn't gone anywhere. It's just gone into the trust.
That's correct.
Okay, interesting. We have investors who invest through LLCs. They form an LLC. It might be their own LLC. It might be two or more people as members of the LLC. And now one of the members of the LLC dies. I think this is a simple answer.
Well, I tell you, it's an interesting concept because it's different than the family trust. The LLC as an entity owns the investment. So the investment, when the first member dies, it still doesn't go anywhere. It's still owned by the LLC, so there's no necessity for probate. Where the issue comes in is in the legal titling of the membership interest. If the membership interest is held in individual name, then we look to the value of the membership interest. And if it's over, in California, it's $166,250, you go through a formal probate of the membership interest. So we look to the titling of the membership interest. If it's held as joint tenancy, then of course there's no probate. If it's held in the name of a trust, then there's no probate. And that if it's held in a will, then you will have a probate if it's over that amount. Now, if it's under the threshold amount in every state, then you use the small estate affidavit to get transfer of title from one party to another party. So the LLC has a different mix to it. It's the membership interest that is key to determine. Now, in terms of basis adjustment, this is very interesting. The membership interest gets a full stepped up basis to the fair market value. That's without question. But that's the interest in the membership interest. What we typically look for is how do we get another stepped up basis within the LLC in the asset so that you can calculate new depreciation or you have no income tax that would be due upon the sale of the asset. So if the LLC is taxed as a partnership, then we use an Internal Revenue Code section 754 to arrange for the inside basis in the LLC to get a stepped up basis. Now, there's a problem with that because you typically go to the syndicator and say, can you give me a value of this particular interest? Now, if it's a 1% interest, syndicators typically are not going to get a new appraisal of all the underlying real estate just to figure out what a 1% is. So oftentimes it's difficult to get that basis adjustment internally, but at least from the outside, the membership interest will get a basis adjustment. And the question is, how do you value it? That's the big issue we run into.
And then the last one we have, this conversation is bringing some questions in mind. I'm going to ask you, an investor who invested through their self-directed IRA.
So an IRA, whether it's self-directed or traditional, it has a beneficiary designation. And so when an investor, when the participant in the IRA passes away, we first look to the beneficiary designation. And the beneficiary designation will typically name a spouse, children. It'll have someone there who's named. Now, and therefore, if you have a beneficiary that is named, there's no probate because the question of legal title is not in question.
Mm-hmm.
It goes directly to a beneficiary. If the beneficiary is left blank, then you go to the IRA operating documents, and traditionally they would say, if no beneficiary is listed, it goes to the estate of the deceased participant, which now throws you into probate. And once again, you go through the threshold. If it's under the threshold amount, one would use the small estate affidavit. If it's worth more than the threshold amount, you go through a formal probate.
Okay. Well, it seems in this list we've gone through, there are certain ones that I really need to advise the syndicator to get an attorney involved, an attorney for the deceased or someone who needs to do it. And I'll tell you what I've been doing, and through this conversation, I can see that I've been doing some things incorrectly. I have an assignment of interest form that I put out, and it's pretty simple. If it's a voluntary transfer, I, Gene Trowbridge, transfer my ownership to Rick Fenelli for $1 in valuable consideration, and then we send that to the syndicator, and the syndicator sends that to the CPA, who does the books, and he changes the title and knows where to send the checks, and it's done. Okay. But some of the other things that you've been talking about 2 levels of probate. You've been talking about an attorney. I need to alert, and I'm going to ask you if this isn't right, if this wouldn't be better. I need to alert the syndicator that we need to get an attorney such as you in the state where the investor lived to get involved. I mean, I did have this recently where we had a Texas community property with a family trust, and my syndicator just wanted to change the name to the living spouse. And I said, no, I don't think so. You got to find out about the trust. And so, as you said, that was pretty simple. We found an attorney who had drafted the trust, and there was just an assignment of the interest to the trust or whatever it was. And the attorney filled that out. So we didn't have to go anywhere, but we were lucky enough because we could find the attorney.
Yes, you were.
So we're going to have to do a little more research, and this unmarried investor is somewhere where I'm going to tell the people, we probably need to go out and find a next of kin and talk about an attorney because there's going to be probate.
That's right.
I I think community property tied into a family trust, both of those, we're going to have to find an attorney who's drafted those documents on behalf of the deceased. And joint tenants, I don't think we need to do that with right of survivalship. The LLC still owns the interest. There's really nothing on my end of the books or my client's end of the books. We're still going to send the check to the LLC under the same tax ID number and the same K1. It's inside of that LLC they have an issue.
That's right.
That's right. And then through the self-directed IRA, we need to look and see who is the beneficiary. If there's a beneficiary stated, then we can do the transfer. I imagine I could send the transfer document to the administrator of the IRA or the custodian or whatever and say, okay, so-and-so died. Can you tell me if there's a beneficiary? And then they could fill out that document transferring ownership to the beneficiary because it's aren't they the legal person to do that?
Well, actually, you raise a good question. Typically, we find that the custodian of the assets will only deal with the named beneficiary.
Okay.
When one tries to find out who are the beneficiaries, what do we have to do? There's a position of the privacy that they want to maintain. Mm-hmm. So when you have a beneficiary designation under an IRA, it's very important for that beneficiary designation to be made known to you and to the syndicator. Mm-hmm. so that we're not trying to ask the custodian to give up information that the custodian feels is private, and they only want to deal with the named beneficiary. And if the investor doesn't tell the beneficiaries that they are the named beneficiary, sometimes this takes a long time to try and get squared away.
Interesting. Interesting. Well, I'm going to interview Karen Hall here. You know Karen. Yes. In the world of self-directed IRAs. I'm going to interview her in a couple of weeks, and I'll add that to the list of how do you handle this in the world of self-directed IRAs. Okay.
Yes, it is due to the privacy laws. Mm-hmm. Back when you and I first started practicing, and this is in the prehistoric times, things were a lot easier. Mm-hmm. You could actually call up and ask who the beneficiaries are, and they give it to you. You say, well, fine, we'll have to locate them, and you would do what you have to do. But today, there's such a restriction on the dissemination of information that one gets frustrated.
Mm-hmm. That's true. Well, those are the questions that I had, and a couple follow-ups that came to my mind. Is there anything that came to your mind that you'd like to cover that we didn't ask as we wrap this up, Rick?
I'm just going to suggest that each of the investors, when they're making the investment, call their advisor, mm-hmm. and just go through what happens if I die, and have that explained to them based on what the advisor understands about the investor's situation. It's an ounce of prevention that will save headaches way down the road on that. And the reason why it's a headache, Gene, is that the investor no longer is with us. Mm-hmm. They can't tell their story. So we have to go back and try and figure out what the investor wanted to do. So be proactive, ask for the advice, pay for the advice. And that's one rule with lawyers. You want to pay a lawyer for their advice, but don't pay a lawyer to get you out of a jam. Because the numbers are skewed. So pay for the advice, get the right advice, so you have predictability and certainty as to what you want happening with your investment and the other assets that you have worked so hard to earn.
Okay. So on the slide behind me, we have your website, Fenelli.com. Would you like to give us some more contact information?
Love to. The telephone number is 949-699-0000. And I want everybody to know we have a live answering service so that we don't have voicemail. We have a live answering service that will contact us after hours if there's a need or necessity.
Very good. Very good. Well, thank you very much. I appreciate doing this with you, having you spend the time with me. And I'm certain my listeners will benefit from this. And this will be played in a couple of weeks on Thursday at noon Pacific Standard Time and put in our YouTube channel with the other interviews we have and for posterity, right, for you and me. So I'm glad you're feeling well. We're doing well over here. And thank you very much, Rick. I appreciate it.
And thank you, Gene, and to you and Kay, a wonderful St. Patrick's